um, uh, development, but I want to talk about why those provisions are in place, and that tells you something about how you should implement those. So let me go ahead and start my screen, and then what we're going to do, because it's very hard to take questions during a Zoom presentation, is to have questions at the end. But feel free to, at that time, raise your hand or type something into the chat box, and we will start from there. Now let's see if I can get this to work. Does everyone see the slides? Okay. Um, what I'm going to do is go through each of these areas. Um, Due diligence, um, the typical phase one and phase two. And as I said at the start, I want to talk about why we do the phase ones and phase two and what you have to look at that. The Brownfields program, and I saw Wayne Capel on here, so he certainly had familiarity with that, and Paul Hayden, who's on it, could probably teach it. And wetlands, forest conservation, critical area law, and a new topic added this year, climate change. There may be other things that we can talk about as we go through this, but I think those are the ones that I most want to cover. Due diligence. Everybody's familiar with phase ones and phase twos, but I'm not sure that most practitioners know why we do phase ones and phase two. It's not just, well, you have a dirty piece of property, so you want to know if it's clean. It actually is a liability protection, a safe harbor. The Superfund law imposes liability on anyone who owns a piece of property. You don't have to have caused the contamination. If you own the property, you become liable for the cleanup of the property. And that is the case even if you had no reason to know that the contamination was there. Worse yet, it's what imposes what's called joint and several liability. What is that? It means that if everybody else is broke, you get stuck with the full cost of the cleanup, even if your involvement was very slight. I know there was a piece of property in Baltimore at one time where a guy bought it, owned it for one day, and flipped it. He apparently knew somebody who wanted it and got a contract to purchase it, locked it up, then flipped it. Both the original owner who had contaminated the property and the new buyer declared bankruptcy. So this poor guy who had owned the property for one day was stuck with the cost of cleaning up the property. So what we had is a situation where if it was an industrial piece of property, the dangers were so great that nobody wanted to buy industrial properties. So as a result, the Congress decided they were going to create this safe harbor, what they call bona fide innocent purchasers. You're not innocent just simply because you did not know there was contamination. That's not enough. What the law says is that you had to have made all appropriate inquiries. Well, what does that mean? When the law was first passed, nobody really knew. I mean, how much investigation do you have to do before you purchase a piece of property in order to qualify for this protection from liability? And fortunately, EPA came along and created this safe harbor. Um, you may be able to qualify as an innocent purchaser without doing a specified phase one and phase two. But if you've done a phase one and phase two and admit the criteria established by the American Society for Testing and Materials, then you have that protection. Then you are guaranteed to have qualified for the exception of an innocent purchaser. Now, I'm going to go a little bit into more detail of this, but let me make sure everyone understands. Having done the phase one and phase two correctly and qualified as a bona fide purchaser, It means that the government can't hold you liable for the cleanup, but it does not mean that your property will not lose all its value. I've seen sites where people do a phase one and phase two. Um, Contamination is found, and they go, well, I should still be able to develop it because I did a phase one and phase two, and we didn't see the problem. No, you may be in a situation where the government can't force you to clean it up, but you may be having to do a cleanup simply because that's the only way to get a value out of the property. So keep in mind the phase one and phase two is not a blanket protection for everything. It's just a protection from liability. And therefore, it is important to you to make sure that it doesn't simply meet the minimum requirements for phase one and two, phase two, but does enough work to assure you that the property is clean enough to be developed. So how do you do that? First thing is you want to look at the consultants you're hiring to do the work. I mentioned Paul Hayden because I saw his picture on this. There may be others, very qualified consultant, very capable of doing this work. But I've seen consultants out there who are not qualified, right? They meet the minimum requirements in the ASTM, but that either requires an education or experience. And I've seen people who are basically industrial hygienists who are maybe they worked on asbestos cases or something, and therefore hold themselves out as people able to do phase ones and phase twos. Um, you're depending an awful lot upon the abilities of this consultant. I don't recommend that you simply pick the cheapest consultant that's out there. Sometimes the good ones are the cheapest ones because they're trying to do volume, but you need to look carefully at those credentials because a bad phase one and phase two, even if it meets the minimum requirements to protect you from liability, can leave you stuck with a property that is worthless, or a property that has to be sufficient. You have to spend a lot of money on remediation on to get value out of it. So look closely at those credentials. And if it's a problematic site, an industrial site, a site where there was a dry cleaner at one time in a strip shopping center, you don't want somebody who's got just enough credentials. You want to look at somebody who has uh, dealt with those kinds of properties a number of times, has relationships at the Department of the Environment, knows what's going to be acceptable and what's not going to be acceptable beyond having read the regulations. And then when you've picked that consultant, um, I see this again and again. Clients, they get the proposed uh, engagement letter from the consultant and they just sign it. You need to look carefully at those contracts and determine uh, uh, whether there are provisions you want to change. I once had a client, a large national builder, come to me and they had bought a piece of property. They had built houses on half of it. And they had discovered that there was an arsenic problem. When I look back at the phase one and phase two they had done, um, the property was being built on an old golf course. Um, Golf courses, by definition, have a recognized environmental condition, and therefore you need to test the tees and greens because the excessive sometimes application of lawn chemicals and pesticides and herbicides can yield high arsenic or high other chemicals. In this particular case, I was told that the environmental consultant they hired because he was a golfing buddy of one of the managers of the company. He did a phase one and phase two, did not identify the golf course as a environmental problem, did not do soil testing as a result. When I looked at the contract that the consultant had given the company, it said that his limit of liability was to refund the cost of the studies. So this company, which was going to have to go back and offer to repurchase back the houses which had been sold, and then excavate a good foot of soil on their lawns of these houses and replace it, the most they could get out of the consultant was a refund. That's the kind of thing you need to look at when you look at this contract. Typically, what I will want to do is ask the limit of liability to be changed to match the insurance coverage of the consultant, so that I can make a claim for negligence up to the limits of their policy. But you want to look at that. You want to make sure that they are indemnifying you for negligence in preparing the report, and look at those terms of the contract. They are, particularly in large deals, negotiable. The other thing you want to look at is what are the terms for the ownership of the report. The reports always come in and say these are solely for the use of the buyer. Uh, if you anticipate that there are going to be other parties brought in who may want the report addressed to them directly, you may want to talk about that with the consultant themselves. Understandably, consultants, if they're are going to give reliance letters allowing other non-owners to share in the use of a report, will charge an additional fee for it. So you want to look at those issues up front. Now, once you've got the consultant and you've sure that it's being done by an environmental professional, what are the elements that need to be in the report? Again, often see clients who they don't look at the phase one and phase two to make sure that it is complete. They flip to the executive summary and they say, okay, is this done? It's done. Now, if you've got a very good consultant, they're going to be careful to check all of these. But if you don't have a very good consultant, or you have a consultant who simply makes an error, some of these points could be missed. And it does not meet ASTM standard, and therefore does not provide that safe harbor that we talked about unless it includes at least these elements. There has to have been an interview, or at least an effort to interview owners and occupants, ask questions. There clearly has to be historical information, looked at title, looked at aerial photos, what was the history of the site. If you get an ASTM phase one that says it met ASTM standards, but there's no analysis of title or past aerial photos, it does not meet ASTM standards. Government records. This is one where you got to look at carefully. The consultant should always consult things like the lists of underground storage tanks, the online list of whether there is any reported contamination or remediation on the site. But typically what happens in these deals are that a Public Information Act request or Freedom of Information Act request will have been made for government records, and the results will not have come back by the time the draft phase one is presented to you, because the deal requires you to get the phase one quicker than the government responds to the document response. There you have a little bit of exposure, right? You could take because the consultant will quite correctly say, I don't have these government records, and therefore that part of this I can't answer. I will supplement my answer when I get the government records from the state. It's appropriate for you then to talk with the consultant. What is the likelihood that those government records are going to change any of the conclusions? I'll give you an example. If you've got something that the historical record says was always a farm, and this was always a field in the farm, then the odds that a government record is going to change the result are pretty slim. On the other hand, if this is an industrial site that has been an industrial site for in Baltimore, say, for years, and you don't have the government records yet back, that's likely to be a significant risk that the government records might come up with something you didn't know about before. And therefore, you need to consider whether, even though you have a phase one, whether it's appropriate to wait until that last data gap is filled. And you need to have the conversation with the consultant, because the consultant will quite correctly say, I didn't find any recognized environmental conditions, but I note that I don't have the government records back yet. And if you proceed in the meantime, you do so at your own risk. A field inspection is something that every consultant must do as part of the phase one. It's worthwhile, if you have a very good consultant, to look at checking for other items as well. And I'll come back to those when I talk about what is not in a phase one. And then a consultant and the report must always identify any data gaps. If there are data gaps identified in the environmental report, you need to look at those and have a conversation with the consultant. There are things that the consultant says, I can't answer. It may be something that says, for example, there's a government record that says there was an underground tank and it was removed, but none of the government records say that whether it was leaking or not. So you need to have a conversation with the consultant and say, well, is that a risk that I have to worry about? Or is it's something that we can be fairly confident that wasn't any significant leak? Is there public water available? So even if there was a leak, it probably doesn't matter much. Or is there somebody got a well in the area? So if there was a leak, it would be a big problem. So when you get to phase one, look carefully at these kinds of questions. Now, if the phase one identifies a recognized environmental condition, then you do a phase two, and the phase two will involve some sampling, soil or groundwater. I'll get clients who ask me, well, what does a phase two include? It all depends. A phase two is a targeted investigation and should only look at those items which were identified as a recognized environmental condition in phase one. You don't want to simply go taking lots of samples on a property. You want enough samples to answer the question, is the recognized environmental condition real? And if so, what is the scope of that? And it's two answers, right? The first one is just, is there a problem really at all? For example, if the recognized environmental condition was there was a dry cleaner on this site, then answering the first question may involve just a couple of samples in the dry cleaning site to say, is there contamination beneath the site? That'll tell you whether there really was contamination, but it may not answer the second question, which is how widespread is the contamination? And so on this issue, you need to have some discussion with the consultant, because what you're deciding is, do I invest more money into this property to define how big the problem is, if there really is a problem? You could say, look, if it turns out there is dry cleaning contamination in this site, I'm not going to go through with purchasing the property anyway, so I don't need to spend the money to scope out how big the plume is of dry cleaning contamination. Or you could say, this is a very valuable piece of property, so even if there is a dry cleaning problem, I need to know how big the scope is and whether I can contain it and remediate it and at least keep it from spreading to another site. That second question is going to require more sampling, more investigation, more expensive investigation. So you need to have that conversation with the consultant about how broad you want the phase two to be. Do you want it to be just sufficient to meet ASTM standard, or are you anticipating going beyond that? And that's particularly true if you think this is a property that you may take through the brownfields program. And I'll come back to the brownfields program in a minute, but let me make sure you understand what is not in a phase one, because I've seen clients make this mistake too. They say, I had a phase one done. Why am I now finding out there's asbestos in the building? A phase one does not look at asbestos survey. It does not look at wetlands to say where you have wetlands or where you don't. It does not look at a critical area determinations to decide whether you have a problem with building in a particular area adjacent to a stream or so. And it doesn't do any testing. If you've got a tank on site, they will look at the tank and say, is there any evidence of leaks? But they will not test the tank to say whether it's intact. For example, an above ground tank, they'll look and say, is there staining under the tank? But if the tank has leaked and the seller of the property has put clean soil under the tank so it doesn't show, you will not know that that tank is leaking. All of those items can be added. Every consultant that I know will arrange to take care of these items for you, but it is an additional cost and you need to have the discussion with them. So again, look at the property and say, are you going to need these things? And have that conversation with the consultant when you sign the contract. Brownfields, I said I would come back to this. If you anticipate that this is a property you're going to want to take through brownfields, that's going to require more testing than a typical phase two would involve. And therefore, you'd ought to have that discussion with the consultant while you're doing the initial phase one and phase two. It's always going to be more expensive to mobilize again to go out and do additional testing than it would be to try to get all of the testing done at one time. So when you're looking at the initial due diligence, have in the back of your mind whether you're going to want to go through brownfields. What is brownfields in this state? There's really two parts to what we call brownfields. One is the voluntary cleanup program. That's the program that actually looks at investigating and cleaning up the site. The other, the brownfield revitalization incentive program, is the one that gives you incentives for having done that cleanup. And they're two separate programs, and let me just briefly go through them. With the voluntary cleanup program, there's two end results that you want to get. One is called a no further requirements determination. The other is a certificate of completion. What's the difference? A no further requirements determination says that the property is clean. Maybe you did something to it to get it there, but it says this property as it sits here is clean. And that's really the easiest if you can get to that level. With a certificate of completion, what has happened is as you went in, the property is not clean, but you have developed a plan, a remedial action plan, and the department has said, okay, once you do the remedial action plan, we will declare it clean. And when you present evidence that you performed that RAP, then the department issues the certificate of completion. A lot of clients I've seen assume that this is almost like math you do on a piece of paper, that okay, if I want the remedial action plan, I'll do X, Y, and Z. These are negotiated documents. They're a negotiated plan. You can have a back and forth with the department about what is needed to perform a RAP, how much cleanup you have to do. And particularly for both the NFRD and the RAP, you can have negotiations with the Department of Environment about how much investigation has to be done and what the standard will be for a cleanup. If you've got arsenic on a site, how much lower does the arsenic level have to be? For example, I've had sites where we or redeveloping a closed golf course. One of the things you can do when you've got high arsenic in the greens of a golf course is bring in clean soil and mix it with the arsenic contaminated soil until the level falls low enough to be declared safe. Um, the old phrase, the solution to pollution is dilution, applies there. But you can have negotiations with the Department of Environment about how low that has to be. That's particularly true for something like arsenic, where the background levels of arsenic in nature in Maryland are very high. So how far do you have to take that arsenic level down when clean soil around it already has high arsenic? Again, don't treat these as something where whatever the department says is written in stone. These are negotiated documents where expertise has a role. Why would you do brownfields? I have a lot of clients who come in and they assume, well, I wouldn't do brownfield because this site is not heavily contaminated. There are a lot of benefits to being a brownfield site. There's a lot of expenses involved, but you look at Inner Harbor East, almost all of those properties I took through brownfields, and my clients there made a lot of money off the fact that these were brownfields. Because if you are an inculpable party, you get a significant tax credit. So let me talk about what inculpable parties are. You can do the voluntary cleanup program as either inculpable or responsible. Basically, the difference is an inculpable party comes in and says, I don't own this property. I don't have any liability for it, but I'm willing to voluntarily clean it up even though I don't have any liability. Those parties get incentives. A responsible party says, yeah, I'm responsible for it, but I want a government decision that says that I've cleaned it up. So though I am responsible for the cost of cleanup, I want something at the end of the day that says I've done it and it's clean and I've fulfilled my obligation. Incidentally, a little side story. Why does the word inculpable appear in there? It's kind of a weird name. When we were writing this statute, because I was one of the principal authors of it, and I was in some negotiations on it, my original draft called them innocent parties. And I forget who, I think it was one of the staff people at the General Assembly, had pointed out that bona fide innocent parties was a defined term in the federal statute and was concerned that it would be confusing. We had an old Wang word processor that had a thesaurus on it, and we typed the word innocent in there and asked for synonyms, and it pitched out inculpable. And that's the reason why Maryland law uses inculpable. And some states, by the way, have picked up on the term after that. They did brownfields after that. I once had somebody try to argue to me that it should have been unculpable. But anyway, inculpable's in the statute. The tax credits can be huge. And they vary a little bit from county to county, and they vary a bit if you're in an empowerment zone or not. But it can be a 50% credit against the increased assessment resulting from the development of the property. So, for example, you have a parking lot in downtown Baltimore, and you're going to put a 10-story building on it. If you time it right, then you get a 50% tax credit, not merely on the increased assessment from cleaning up the property, but from putting the 10-story building on it. And that 50% credit on the increased value continues for 10 years. So you can imagine that for Inner Harbor East, where we took, an old lumber yard or a closed a chemical plant and put a high rise on it, the tax credits just from brownfields before you put a pilot or anything else on it were huge. I used to tell people that this is one of the few situations where finding a minor problem like a leaking underground tank could be good news rather than bad news. Um, but you have to recognize that there are some things the voluntary cleanup program doesn't do. Though it will protect you from liability for the pre-existing conditions if you're an inculpable party, it specifically says if you do anything to make the situation worse, you're liable. So you have an underground tank, there's contamination in the soil, or your contractor, while he's digging it up, spreads the contaminated soil to a wider area. You're not protected from that. You're not protected from suit by a neighbor. Okay. If you go into this site and you're going to stabilize it and clean it up, but there's a plume that's leaving the site and impacting neighbors, you still have to deal with that neighbor. Now, if you have the Department of the Environment saying that you've cleaned it up enough that it is now to be declared clean, it becomes hard for the neighbor to sue you, but there is no legal boundary on that. And then obviously doing the cleanup doesn't guarantee that there's not going to be an impact on the property value. For example, you may have a site where the department has said if you put a cap on it, we'll declare it clean. But then the lawyer will come along and say, because you have a cap on that site and an environmental covenant that says that the cap can't be cleaned up, you have to disclose to any buyer the existence of that cap and the existence of the contamination. So it can be a marketing issue that you have to deal with. My experience is that in urban areas, there's not much impact from the fact that there's contamination under a cap. If people are going to put up with schools and crime, then worried about something 10 foot under the ground doesn't bother them. But you start moving into suburban or rural areas, you get much more of an impact. Now, in addition to the voluntary cleanup program, as if there weren't enough acronyms on this, the department also has something called a controlled hazardous substance program, and you can get a no further action letter from that. And I get clients who are confused with, well, what's the advantage of one versus the other? Simply put, under the CHS, it's a lot faster and easier. You don't have public comment. You don't have a lot of the additional investigation that the department may impose. But one, there are no tax credits. And two, the letter you get from the Department of the Environment on the CHS program is an opinion rather than a binding document. Under the VCP, they cannot sue you for cleaning up a site once you have completed the VCP program. Under the CHS alternative, they give you a no action letter that says, based on everything we know, we don't think you need to do anything further. They reserve the right to change their opinion. It is very, very rare for them to change their opinion. There may only been 2 or 3 times in state history where they've done that, but they do reserve that option. And then recently, as Paul Hayden could tell you, the department has begun doing a hybrid program where you come into the VCP, get your inculpable status so you qualify for tax credit, then you suspend that and go do the cleanup under the CHS program, and then come back into the VCP to complete the process in order to get the tax credit. If you're doing this, you need to have an experienced consultant, and I would suggest an experienced lawyer helping you with this, but it does work. It's probably the fastest way to do a cleanup, and you qualify for the tax credits. And let me mention one thing more on the tax credits. Though the tax credits are huge, they run with the land. So if you're doing a commercial building or a multifamily building where you're going to rent out apartments, those tax credits are worth a lot. If you're doing single family homes, then the tax credits are going to be given to the buyers of the home. It may be a marketing advantage, though it's kind of a strange conversation you have where you have to tell people, look, this site was contaminated, so we're going to get you lower property taxes. And therefore, often developers of single family homes or fee simple homes are less interested in it because they don't keep the tax credits themselves. New area, wetlands. Wetlands has probably been one of those areas where we've had the most difficult and contentious issues. And it helps here to go back to where did the idea of wetland regulations start? The actual federal statute gives the feds the authority to regulate waters of the US and then defines waters of the US as navigable waters or waters that are impacted by interstate commerce. Now, Maryland has broader authority. They also regulate tidal waters, non-tidal waters are broader authorities. But the federal definition is waters of the US state, navigable waters, and waters impacting interstate commerce. When you look at that term, you think, okay, that's a river, right? It's something you can drive a boat up, maybe impacting interstate commerce. Okay, there might be some canals and so forth that affect, and I apologize for my schnauzers, that impact interstate commerce, but we're talking about something beyond a small creek. Hold on one second while I close my office door. One of the consequences of working from home. But the issue has gotten much more complicated than that. The feds have decided that navigable waters included anything that is connected to a stream that could be navigated. So if you have a creek that goes into a river, then they consider that to be navigable waters. They then decided that waters impacting interstate commerce would also be any waters that could be used by navigating waterfowl, because hunting is a commercial activity, and therefore if the ducks land in the pond, that is waters of the US. So as a result, wetlands became a very broad concept. And I'll come back to just how broad. Recognize with wetland permits, there are two kinds of permits. And you'll see this often discussed when you're dealing with your consultant on permits. A general permit, for example, something where you got less than 1 acre, it's issued very quickly. It's not much of a review. You can get this done very quickly. So if you can limit the impacts on wetlands to less than that 1 acre, it becomes a whole lot easier. If you're having an impact on more than 1 acre of wetlands, you got to get an individual permit. That's going to have a lot more public notice and comment and take a lot more review. If you're having an impact on a tidal water, it's not going to be enough to get a permit from the Department of the Environment or from the EPA to impact the wetland. That's because in Maryland, the state considers itself to be the owner of all water below the high water mark, the high tide mark. And therefore you need to get a license from the Board of Public Works. A license, it's not the same as a permit. A license is basically a lease that says, okay, the state says that it's okay for you to use this portion of tidal water. Go into the Board of Public Works, which is the governor, the treasurer, and the comptroller, can be a very lengthy process, because you have to, the board only meets typically once a month or so, and their agenda includes everything that has to do with the budget or contracts or most everything the state's doing, so it can be hard to get in there. And two, if it becomes a contentious issue, then you can, there's a lot of politics involved. I've seen sites held up for a lengthy period of time because there was political opposition, and the governor, the treasurer, the comptroller had problems with the proposal. The permit process, again, it depends on the size of the impact, the importance of the wetlands. Small impacts get a review by the Department of the Environment. Large impacts are going to involve the Corps of Engineers. New subject, because I got to watch the time here. Forest Conservation Act. This is one that is, I don't spend a lot of time in this, though I've got a bunch of slides here, and I'll make the slides available to anybody who's attending. The problem is the Forest Conservation Act of the passed by Maryland is a minimum requirement. It says all of the counties must have at least this kind of standards for forest conservation. But frequently jurisdictions have required a lot more. For example, in Anne Arundel, the forest conservation is a whole lot bigger problem than it is in, say, Carroll County. So you have to treat these as this is the minimum you're going to have to do, but you're going to have to look at each county to say, is there more that has to be done? And typically the provisions apply to anyone seeking a subdivision, grading permit, sediment control permit. The state requirements only apply if you're basically doing an acre or more, but again, counties may require more. The state statute has 13 exceptions, things where you don't have to do the forest conservation, agricultural activity. Energy projects is something that there's some discussion on. That is, if you have to cut down trees in order to put in a solar farm. It looks like they probably are exempted in most situations, but it's not yet accepted by everyone. Cutting down a certain number of trees for the property owner of a child, that is, someone has a farm and they're building a house for someone, Allegheny and Carrot have special exceptions. But again, these are the state requirements. A local jurisdiction could decide to eliminate any of these exceptions. What do you have to do? You have to do a forest stand delineation. You have to do an inventory of what forest is on the site, and then develop a forest conservation plan, how you're going to retain and protect those forested areas with special attention to certain priority areas. If you, as part of this compliance requirement, you can do reforestation or afforestation, right? Reforestation is restoration and replanting of a forest, and afforestation is conversion of bare and agricultural land to forest. The agencies prefer reforestation because a lot of times the afforestation, where you've gone and planted new forest, they fail and the trees die. Reforestation, it tends to survive. To avoid that, you got to obtain at least 20% of your existing forest. Again, these are the state requirements. You need to check your individual county to see if more is required. We move on to critical areas. Most of you probably will have dealt with this program a bit, but I do see clients that have some confusion about exactly how broad the critical area law is. And once again, like the forest conservation, you have a state program, but then you've got to look at each of the county programs. The way the state programs work is it's an oversight program. The counties have to come into the state and say, this is what we're doing with our critical areas. And then the state approves it, but the implementation has to be done on a county by county basis. What is the critical area? This is where I see some confusion. People think the critical area is 100 foot from the high tide. It's not. That's the buffer. The critical area is 1,000 foot from the landward edge of all tidal waters and tidal wetlands. About 11% of the state of Maryland is in the critical area. Now, that's a whole lot more on the Eastern Shore, for example, than it is going to be in Montgomery County. But on the state as a whole, about 11% of the land falls within that area. As I said, the Critical Area Commission is the one who oversees this. And if you have to go to the Critical Area Commission, they're only going to meet monthly. And so there could be significant delays in getting approvals. The key to the Critical Area Commission is all of the land in a county is designated to one of these 3 categories. The county has to set aside a certain 80% of it for resource conservation, 15% for limited, and 5% for intensely developed. It includes most everything, right? And you'll find the restrictions in the critical area can be significant. And that's again the 1,000-foot area. Your reforestation requirements are tougher. You can't construct on slopes. You may be limited on how much of a lot coverage you have to have. You may have a 200-foot buffer from the water for new subdivision. Once you move into the critical area, that tends to override a lot of the other planning that you would normally do. Examples, this is a resource conservation area, one of the most protected areas. What you can see outlined in that black dotted line, you can't develop at all. And in fact, you're going to have to keep the forested buffer. So you can't cut down some trees to give a better view. As you can see up in the right-hand corner, there's an area outlined in red. That's because somebody found a rare species in there, a rare turtle or something. So you can't do that at all either. If you notice up in the upper left, there's a dotted black line that's broader than there's a dashed black line that's much higher up than the dotted black line. There are restrictions there about harvesting. Requirements are pretty extreme. Limited development area, you've got a little more ability to do some work. The reforestation is not as bad. The lot coverage is a lot better. A limited development area might be something like this. Again, you still have that buffer along the front line that you have to restore, but the requirements further back are a little better. If you notice, you've got a lot of developments in that area, both multifamily and single family homes. So it's a little bit easier. Intensely developed area is an area where there's going to be a very little critical area requirement. There'll still be some. Here's an example of an intensely developed area. You still got the buffer that exists from any pre-existing operations where there's forest. But if you notice, there's some maritime, there's some boats, there's some pre-existing structures, there's some marinas, things that are water dependent activity are going to be in an intensely developed area. Will be able to cut through the buffer, and the restrictions outside the buffer are not very great at all, right? You can see there's tank farms in there, there's very dense development, there's factories, again, because it's an intensely developed area. So you treat it like it's some broad zoning requirement that you have to achieve. Coverage, you'd be surprised at the things that consider coverage, fences, walls, a deck. You're going to have to look into that kind of details when you're looking at how much of the area you can cover. And I see I'm running a little short on time. So let me change to the last of the big topics I want to talk about, and then we'll see if we can squeeze in some questions. Climate change is something I'm adding this year. It's not something that has a lot of requirements yet, But I can see over the next 5 to 10 years, you're going to have in developments a lot of requirements that come out of climate change. The Maryland greenhouse gas reduction requires the state to adopt a plan to reduce greenhouse gases by 40% compared to 1960 standards. And the Hogan administration has proposed to change that to 50%. Some of the legislators, including Chairman Penske, want to change it to 60%. Meeting those kind of numbers inevitably means many changes to the building industry. What kind of changes? First of all, we got the sea level rise issue, right? If you look at this chart, those colors there are how much land would be covered depending upon exactly how high the sea rise occurs. The green colors are almost certainly going to occur. The blue covers and red colors are, I've got that backwards. The blue and red colors are the colors that are almost certainly going to occur. When you get up into the green, it's less likely. But you can see, particularly on the eastern shore, we're going to lose a significant amount of land if the predictions hold true. Some of the others are going to happen if we have more extreme rises. So you got to expect that there are going to be regulations further restricting development in those areas. They may require the elevation of houses. They may restrict how many houses can be built. You can certainly expect to be restrictions on roads going through those areas. So expect that to come. Another area that I think there's going to be a lot on is the building codes are going to be changed to force higher energy efficiency. You're going to have restrictions imposed. Most immediately, I think, restrictions to stop natural gas hookups. So houses are going to be forced to go all electric. So again, that's something over the next 5 to 10 years. And since it's been now 57 minutes of my hour, I'll stop and say thank you and then ask, do we have time, David, for any questions?
Yes. Carrie, do we have any questions in the chat box?
David, I do not see any questions in the chat box right now, but I'm
Okay,
sure once you get going, they'll have some.
I have a few though. Michael, what do you see the regulatory impacts on home building as a result of climate change going forward?
Yeah, one I mentioned, which is I think that we're going to see over time a prohibition on natural gas hookups. And the interesting implication of that, I mean, that because they're trying to move electricity to all renewable power so you can eliminate fossil fuel usage. And if you're using natural gas to heat or cook, then obviously there's fossil fuel going on. But one of the implications of that is that once you have fewer users on the system, but still all of those pipelines to maintain, the cost of natural gas may start to rise. So I think there's going to be a movement toward more energy usage. I also expect that within the next 5 years, the changes of building codes are going to require not merely more energy efficiency, but requirements for either solar ready roofs or solar roofs. I expect solar ready roofs to come first. It's already the case in California. If you build a new house, it has to have all of the connections necessary for somebody to put solar panels on the roof. Some jurisdictions are starting to move now to require solar panels on the roof. I think we'll get there. The question is when. Also, we're converting to electric vehicles. I know that's very few right now, but it is inevitable that at some point in the future, you will not have internal combustion engines except at antique shows. And the question is when. Well, part of that will be that people are going to need to charge their cars at home. And so I think there will be changes in the building code to require people to have the electric wiring in place to add a high-speed charger.
Mike, I think we can squeeze in one more question. There was a new bill passed at the legislature in the prior session regarding mitigation banking, which a lot of us did not understand. Could you give us the executive summary?
Yeah, briefly, the mitigation banking is where you, as defined in the original statute, was if you created a forest, then you could use the trees in the bank rather than having to go out and plant new trees yourself. So people created these banks where they went out and had an area of trees, and they say, rather than you go and plant your own trees, I'll basically sell you the rights to my tree. The Attorney General came out and said that that required the banks to have been creating new forests. Previous to that, what had been occurring is the banks, these mitigation banks, had gone out and located existing forests and put covenants on them to preserve the forest. So the view was, if you stop this forest from being cut down and you guaranteed for the next 30 years it would not be cut down, that was the same as planting a new forest. The Attorney General said that wasn't going to qualify. Fortunately, the building industry got legislation passed that rolled that back in part. It said those mitigation banks could continue to use their trees in lieu of planting new trees, but only if the banks had been created prior to, I think it's December 2020, and then some limitations on what percentage. So that has preserved a cheaper mitigation banking scheme for the time being, but eventually that's going to give out as well.
Great. Mike, that was absolutely terrific. As always, I hope everybody enjoyed it as much as I did. That concludes the spring session of our land development course. We will pick up after Labor Day on September the 14th with some more lunchtime webinars on the 14th. We're going to tackle working out in the West. We can all wear our cowboy hats when we get there. And we're going to talk about land development in Prince George's and Montgomery counties. And our speakers will be Christopher Hatcher and Peter Goldsmith. I hope to see everybody then.
David, I hate to interrupt. It's Carrie. I think we have a question in the chat. Did we get that answered, Becky?
No.
Okay, but David and Michael, we got a question. I just want to take
care
care of all of the customers.
What's the difference between regeneration and afforestation? Well, it's reforestation and afforestation. Michael, you want to tackle it?
Yeah, reforestation is where you had an area where you cut down some trees and then you replant the trees in that space. Real quickly. Whereas afforestation, you are planting trees here. You're planting trees that in an area where there were not previous trees.
Well, I think I would add to that there are both reforestation and afforestation requirements. So if you have enough trees, you can cut down some, but if you don't have enough trees, you must afforest. That is to plant trees where there aren't some now to come up to a certain threshold. So I hope that answers the question. In any event, thanks you to everybody for joining in. Mike Powell, thank you again. You're just terrific. You're just a wonderful speaker on this subject. I wish everybody a wonderful summer, and I hope we'll see you again in September. Thank you so very much.
Take care.
Thank you.
Goodbye.
Thanks for everything, David.
Wade,
Thanks, everyone.
Wade and Cables, let's have lunch. Thank you, you too.